Should you leave the house during a divorce? This question comes up a lot. And unfortunately, the short answer a lot of times is no, it's not the best thing to leave the house during a divorce. Now, there's a lot of exceptions to that. That's just with the basic understanding. If the two parties have a child or children together and there's no domestic violence or physical violence issues, it becomes a situation where a lot of times, as a Florida divorce lawyer, I'm advising my clients many times that they need to stay in the house, or it's best for them to stay in the house. Because again, the issue arises that if you don't have an agreement or there's no court order about it, if you exercise what the courts might consider self-help and just leave the house, maybe the child's been living there for 5 years and going to school, and the children that they're friends with are in the neighborhood and all these different things, and now they're moved across town, the court can look at that and the court can say, you need to go back, or the child needs to go back. So the court has the ability to do that. So that's why sometimes we have this discussion prior to the filing of the divorce or after the filing of divorce, or whatever the issue arises and comes up. A lot of times it results in both parties continuing to live together in co-parenting and time sharing while the divorce is going on. Now, this is not across the board. There are many situations where it is not a good idea for both spouses to be in the same house together, and especially those situations involving domestic violence. So when there's domestic violence, that's a whole separate set of circumstances and a separate burden that has to be proven for the judge to enter a domestic violence injunction. So that's something you would discuss with an attorney. I'm a Florida divorce lawyer. I've been practicing in Florida for almost 2 decades now. And again, I suggest that you speak to an attorney, whether it's me, whether it's somebody else, but speak to somebody if you're in a Florida divorce or you're in a situation in where you have this question. Purposes of this video is where there's no domestic violence inherent and there's children that are shared between the parties. So both parties are going to normally want time sharing with the children. So therefore, it's complicated for the court to be able to say who stays and who goes without hearing everything. And sometimes that occurs at a final hearing. So it's sometimes too early to be able to do it at the beginning of the case. There are different ways to move for what's called temporary relief, and those situations are specific to certain cases. Not every case will a court on a temporary relief basis hear a request for what's called exclusive use and possession of the marital home. So that's what you're asking for, is basically to exclusively have possession of the marital home while the divorce is still pending. And that's a complicated argument to be made. Sometimes people think, well, why is that complicated? Well, again, if you're both entitled to possession of the home, it's complicated for the court to say, well, then this other person needs to get out. That's why a lot of times people end up staying and residing in the same house with the children while the divorce is pending. And then at a hearing at some point in the case, usually the final hearing, the court would make the decision. But again, that is if this is a contested case that goes all the way to a trial. Most cases end up settling somewhere before a final hearing, but it's still tough. And I don't enjoy giving that advice because I know a lot of times when that question is coming with the lead up questions to it, and then when I have to say a lot of times, hey, I know this is going to be tough, and I'm unfortunately asking you to be in a pressure cooker situation, and I understand that. But the flip side of it is that if somebody leaves and they were not supposed to, and they take the child, or they leave the child in the home and they've kind of relinquished time sharing, it just becomes more complicated sometimes than it needs to be. If you have a specific set of circumstances in which you feel that are different from what I've discussed in this video, then absolutely. And in any situation, you should discuss it with an attorney to make sure that you're informed about the law based upon your specific set of circumstances, because every case is different. And that's how I approach it with my clients as well. And that's how judges approach it as well, that each set of circumstances is going to be different in each case. So they have to look at it specific to that case, specific to that child, specific to those parties. So when they look at it, they try to determine what's going to be the best situation. And a lot of times, I'll say unfortunately, because it's tough. It's not an easy thing that I have to advise. And then I know it's really, really tough when you're going through the proceeding. And sometimes it can take a while and you're having to continue living with that person. Now, if you don't have children with the person, that's different. Sometimes people feel like they're abandoning the home if they're leaving. But again, if they don't have children and they're on the title and they've made it clear they're not abandoning the home, they just don't want to be in the same situation, sometimes that can be a good set of circumstances, especially if there's somewhere else that they can go. If they can't afford two homes while the divorce is pending, maybe they're waiting on the sale of the marital home in order to be able to get the equity from it, so then both can purchase their own homes or be able to go out and rent until they figure out what they're going to do. Again, these are things that you need to discuss with an attorney to determine what your different options might be, because in any of these situations, the circumstances are going to dictate what the outcome is going to be. So thank you for watching. I appreciate it. Hang in there.